session pursuant to adjournment.
Good morning, ladies and gentlemen. Our first case this morning is 2019-951 Craig D. Corder et al. Versus the Ohio Edison Company. For the appellant, Ms. Hasbrook.
Yes, thank you. I would like to reserve 2 minutes for rebuttal, please. My argument will focus upon two issues, and I'll begin with jurisdiction and then proceed to the alternative argument that the purpose of the easement language affords the ability to an authorization to apply herbicides. Turning first to the jurisdiction issue, the court erroneously found an ambiguity here where none exists for the state court to resolve before the PUCO would be allowed to exercise its exclusive jurisdiction. As this court is well aware, there was confusion in the case law between PUCO jurisdiction and state court jurisdiction before Allstate was decided in 2008, establishing the two-pronged test. There still was confusion in the area of vegetation management following that decision until Corrigan was decided by this court in 2009. Like Corrigan, this case does not dispute any boundaries of the easement, the validity of the easement, work to be done under the easement, nor does the record show that the purpose of the easement is disputed. In fact, none of the affidavits put in by Ohio Edison are disputed at all. The affidavits state that the herbicides are specified for this application under vegetation management plan that is filed with the PUCO. It's industry practice that this vegetation may interfere with or endanger the line's operation, and that herbicides are necessary in order to maintain the line. Now in Corrigan, as this court is well aware, it was decided that vegetation management, and where that is the challenge, it is manifestly service related. And the decision to remove a tree was governed by the plan and not a word in the easement, according to this court. After a review of the entire record, the plaintiffs in Corrigan were contesting and challenging the methods. The same is true here. And the decisions have been very uniform for the past 10 years. And we cited in both of our appellant brief and the reply, the decisions, and they all followed Corrigan. The decisions until this one, the decisions cited by appellee are either inopposite in that they did not involve vegetation management, therefore the PUCO jurisdiction was not invoked, or they were decided before Corrigan. So in this case, now we look at the entire record. That's what Corrigan told us to do. The courters continually admitted in the record that the easement language was unambiguous. They started with the complaint, paragraph 17, saying the clear and unambiguous language of the easements in their view didn't allow First Energy or Ohio Edison to apply herbicides. They continued in their motion for summary judgment in their heading on January 17th of 2018, saying the language was plain and unambiguous. And then in the opposition to the cross motion, they state, plaintiff's complaint stipulates to the fact that no ambiguity exists. The appellate opinion also found that and said that the parties agree that the easement language is clear and unambiguous, but then went on to devote time and to what they felt was an ambiguous term. Here, the challenge is the same as Corrigan. The challenge is the method of removal. In Corrigan, the plaintiffs believe that the silver maple tree should be trimmed instead of removed. And here the courters believe that the vegetation should be mowed instead of the use of herbicides. Now the court, and focusing still on Corrigan for a moment, the court rejected that there should be a single word to decide the authority of the easement. And in that case, the word was may. The 8th District Appellate Court focused on the word may and said that that may limit some of the authority. And here the court focused on remove, which, by the way, the word remove is in nearly every easement and also was in Corrigan and was not found to be ambiguous. The Corrigan court said that the grantee's decision to remove a tree is specified under the plan regulated by the PUCO rather than a word in the easement. So here the challenge is identical to Corrigan, and Corrigan controls, and this matter should be in the jurisdiction of Corrigan, of the PUCO, according to Corrigan. Subject matter, yes.
Why both sides say the contract is unambiguous? One says that, or the easement, one says you can use that allows you to use herbicides. One says, the other side says it's unambiguously doesn't allow. Why can't the trial court decide that issue and then everything else goes to PUCO. Isn't that what our case law says?
No, well, not in this instance, because the authority is the authorization under the easement is clear here.
But the meaning of the easement, whether or not it includes using herbicides, is clearly a matter of property law, right? I mean, that was your argument below.
And that was because that's what they were arguing below until the appellate court, when they started to use dictionary definitions and bring in other arguments. And so the authority, we believe, is clear in the easement, just the way it was in Corrigan.
So what if we don't buy your argument that PUCO gets to decide the meaning of the easement, at least as to whether it includes herbicides, but we do disagree. But we do agree with you that the easement unambiguously allows herbicides to be used to remove vegetation. Then what should we do?
If the easement, and you concur that the easement unambiguously allows the use of herbicides, because it does allow removal of obstructions too, and cuts in trees and all types of obstructions. And if the court does find that, then it goes to the PUCO to see if the methods were reasonable.
But what would we do in this case? Would we send it back to the trial court and say, instead of dismissing, you should grant a declaratory judgment?
No, the opposite. If there's no jurisdiction for the court to determine the authorization.
But my question is, what if we think there is jurisdiction to determine
if you believe
what the easement means?
Yeah, and if you believe there is, then
what if we adopt the position you took in the trial court?
Then the case is remanded back, and then there's a two-step process to get into the PUCO instead of a one-step process that we believe Corrigan was setting forth, and that is that the court will interpret the easement according to the purpose, and then if there is the right.
I don't think you understand my question. What order should we write if that's what we wanted? If we think the order is unambiguous, or if we think the easement is unambiguous?
Then the judgment would be affirmed, and it would go back to remand to the state court to determine whether the removal by herbicides is authorized under the easement language. Did that answer your question?
Not really, but go ahead.
Okay. I apologize. I don't know what else that the court could do other than either affirm it or remand it. And then if it's remanded, then it would go back. And then if the court says that the authorization is there, then the method of the removal would have to go to the PUCO on a two-step process, because it would be challenged either by First Energy or Ohio Edison or the plaintiff.
Counsel, isn't under Allstate, or I'm thinking setting the right case, isn't the threshold question on jurisdiction is whether PUCO, this dispute requires their expertise? I mean, this is purely a matter of contract interpretation, right? Best suited for a court.
No, we do. I agree with you that the specialized expertise of the PUCO is in the Allstate test. But in this particular case, the purpose of the easement should be what the lower court, the trial court, should be looking at. And so if the purpose is allowing maintenance, then it should stay, the jurisdiction should go to the PUCO, because otherwise the PUCO wouldn't even be able to be looking at the method of the under the vegetation management program if the lower court says that it can't be done under the easement. And I want to talk about the easement and why we believe the court erred in finding the ambiguity. First of all, it searched high and low for a case that said that the word remove is ambiguous, finding West Virginia and Texas cases. The word removed is in almost every easement. And this is the first time a court has said that it's ambiguous. The other thing the court ignored is that there's also the right to remove other obstructions. Chrissy Todd in her affidavit said that vegetation, incompatible vegetation, is a type of obstruction under the NESC, so you have to have the clearance, the proper clearances for it. So the word remove is only in the easement once, and yet the court focused on right to remove, trim, cut, and remove trees, limbs, and underbrush. But then the sentence goes on and says, or other obstructions. And so even if that phrase is confusing, whether we consider it to be an obstruction, which the unrebutted evidence in this record says it is, it is an obstruction that's under the clearance codes that the vegetation management plan is designed to protect. Whether it's an obstruction or a tree, certainly you don't have to cut an obstruction. Obstruction can be a building, a flagpole, a gutter. Obstructions can take many forms. And the rather absurd result that comes from this reading is that the court was positing that we didn't know if you have to cut, trim, and remove, cut and remove, trim and remove, cut, trim, and remove. Well, it ignores that even if that's the case, the purpose is to permanently maintain and be able to remove obstructions. And the easement case law, we go into easement case law, of course, this is a specific type of contract. And it says that the courts do not read limitations where there are none. And here the purpose is plain, that the permanent maintenance in the judgment of the grantee is permitted. And so the issues at hand in this record to determine if the obstruction, if you want to call it, or underbrush can be removed are covered in the record and are unrebutted, that this is for a maintenance purpose. Now, if Ohio Edison was, building a service center or something under it, that would not be consistent with purpose, but it's consistent in their judgment. Three people opine that it would endanger the wires or their operations. It's consistent with vegetation management, and it's consistent with the way the industry is doing it under the modern methods. And Crane Hollow said modern methods can be used. With a permanent right granted in 1948, things changed. And after the blackout, things changed. That's why it's so important that the PUCO, with its specialized expertise, be able to determine how this obstruction can be removed. There's no issue in this record that this is an obstruction and in the judgment has to be removed. Now, if there was maybe contrary evidence that this isn't how you maintain lines, or this isn't industry practice, we could see that there would be a different case. But here, there is simply, it's a disguised challenge, just like Corrigan, to the methods in which the utility in its judgment is deciding to remove. Just like in Corrigan, the challenge was the method of whether it should be trimmed or whether it should be completely removed. And so this modern method in Crane Hollow says that, the parties maybe didn't even foresee the possibility that the easement owner would use that type of aerial observation that wasn't around in 2016. So, I'm sorry, in 1916. So here, this is the modern industry method and the company should be permitted to use it. And the PUCO needs to keep uniformity in these things. They approve the plan that allows this very type of vegetation to be removed in this manner through herbicides according to the plan. And I see I'm into my rebuttal time, so unless there's further questions, I'll hold.
Thank you.
Thank you.
Mr. Anderson?
Thank you, Your Honor. May it please the court, I'm Nicholas Anderson for the appellees Craig, Jackie, and Scott Porter. The case at bar revolves around pure contract interpretation, namely the scope of the authority and rights conveyed in an easement. And as such, we submit that this interpretation remains within the sound jurisdiction of the Ohio trial courts. Perhaps even more importantly, this case reminds us of the rights inherent in real property ownership and how the loss of any right in real property, especially without fault or compensation, is unacceptable. As summarized by this court in Allstate, the PUCO has exclusive jurisdiction over service-related matters, but this does not diminish the jurisdiction of the courts of common pleas in areas of other possible claims, including pure tort and contract claims. Additionally, the PUCO is not a court and has no power to judicially ascertain and determine the rights and liabilities of parties. And as stated by this court in Wilkes, the PUCO does not possess judicial power and may not adjudicate controversies between parties as to property rights. Here, the entire dispute revolves around the interpretation of the phrase trim, cut, and remove in the party's easement. The appellees contend that this language is unambiguous and means two things: trim and remove or cut and remove. Any extension of the interpretation of these two items brings us outside the four corners of the document and should not be permitted. Appellant's argument seems to be that since they are a public utility, any clause in a contract dealing with vegetation should be read automatically to be service related. This sounds
Should we interpret what the phrase means in this case?
You mean this court, or do you mean the
This
remanded
court.
to the trial court to interpret?
Should we interpret it?
The case should be remanded to the trial court for the court to interpret the phrase. Yes.
Well, any reason why we shouldn't do it since we have the case here?
Oh, if the court feels, I mean, if this court would like to, I think the court can, just like the 7th District did, make a ruling that finalizes or definitively ends the case. Of course.
So, and you would be fine if that ruling went either way?
Of course. Yeah, I think that I think this court has a full record. I mean, if you look at the trial court record, Judge Hervey in Harrison County, he had a fully briefed cross motions for summary judgment. He had affidavits. This case was
so you think on this court could, for example, say that trim, cut, and remove includes the ability to use herbicides and remand it to the trial court to grant a declaratory judgment saying that?
I think the court could, yes. I think that the record was fully developed and that the procedure the court would normally follow, I believe, would be to remand it with instructions to rule on that summary, the cross motions for summary judgment, or if there's still issues of fact that the court is considering, to hold a trial or hearing on the matter.
But I think there's no issues of fact, right? This is, you just told me this is purely a matter of the four corners of the easement.
That's what we believe, yes. We believe that on the cross motions for summary judgment, this court could rule definitively on this case without remanding it to the trial court to make a judgment in that vein, yes. So appellant, excuse me. Now, the 7th District admittedly went a bit outside the scope of the appeal and found the word remove to be ambiguous and looked at materials outside the contract to determine the meaning of the phrase trim, cut, and remove. Although appellees appreciate the help, as we admitted in our briefing, we believe the 7th District went a bit too far with its opinion, and the only thing truly before this court today is whether the rights under the easement should be determined by the trial court or the PUCO.
Except
In all states, this...
let me just clarify though, except that you've just said to Justice DeWine that we can decide that. So
yes, I believe I believe this court has a fully developed record, and if it would like to rule on the factual background of this case with the record it has, it absolutely can.
I assume though what you would also want us to say is that that's a factual matter that in the first instance has to go to a trial court as opposed to the PUCO. If we're deciding the terms of an easement.
I agree. So Justice DeWine mentioned in Ms. Hasbrook's argument that this is a purely contractual issue. And I think that at that point, the trial court has the first shot at the language of this contract. And if you read the language of the contract, it was written in 1948. The Public Utilities is a sophisticated party. It knew what it wanted to do. And if the PUCO can't determine the rights of the parties here, then a landowner loses its meaningful shot to argue that the scope of the easement, the actual rights conferred by the easement aren't that broad. And in this case, it's trim, cut, and remove. And so, we obviously believe that herbicides, there's no removal, there's no cutting, there's no trimming. In fact, their expert testified.
Counsel, do you think a herbicide does not remove the vegetation?
It does not. Actually, their expert testified in the affidavit that they have to spray it multiple times, different treatments over time. And even then it may not completely go away.
Well,
So,
it
no,
may not, but it may also. But the same thing holds true when you've got to trim. You've got to do it multiple times. Growth comes back, a limb grows back, branches expand, that's a multiple process as well.
I agree, but that's trimming and cutting. That's within the scope of the easement, whereas removal, because that
Well,
comma is missing.
you're using remove, trim, and cut to do the same thing, which is to manage vegetation. And whether you have to do it, whether it doesn't say to permanently remove, it's to remove the obstacle, to remove the threat to the, according to the plan, but nothing in the language says it has to permanently remove it once and for all, one shot, right?
I believe that you can read remove to say it means to remove it permanently. I mean,
Well, you
when
could, but you don't have to.
well, when you trim a branch, you remove the branch. That's the removal part is to the trimming and the cutting, not the actual tree. I mean, to pull out the roots and all that stuff. I mean, I think that the trim and cut, when you read it in conjunction with remove, which is what the lack of a comma
So
creates.
you're saying that if you cut a tree, that's a temporary measure because there can be other branches that grow and are just as obtrusive, correct?
What I'm saying is that when you cut a tree and you remove the part you cut, you have done something permanent. If the tree grows back and you have to cut it again, you'll still remove the piece. When you spray herbicides, you never remove anything. It never leaves. It dies, then it grows back, and then it dies and it grows back. There's never a removal.
Counsel,
That's the problem.
Wasn't the catalyst for this dispute your client's objection to the use of herbicides?
So basically, our client, this is kind of unique because our client has, I think, 7,000 feet of line here with a 100-foot easement. And in the past, they've always been able to put a sign up or send an email saying, hey, please don't spray our easements with herbicides because they have livestock and wells and things like that, and herbicides leach. So basically what happened is that this time around, we asked them, please don't do that. And they said, we're going to do it. And so that was the impetus to file the declaratory judgment action, which led to where we are today.
So getting back to Justice DeWine's question, are you really comfortable with this court making that decision if the majority of the justices here feel that herbicide falls within the removal language? Don't you think that's better suited for the trial court, a fact-finding court, than a reviewing court?
So that's a very double-edged question for me to answer. I would respect the decision of this court if it decided to rule on it. However, I think if this court, the threshold matter here for this court is who should be making this decision in the first instance. And if the court decides that's the trial court, which is what we believe, the trial court needs to construe this easement because the moment it gets to the PUCO, they don't have the authority to construe it. They have no authority to do that. Once this gets to the PUCO, the only thing that becomes a question is whether or not it was reasonable to use herbicides.
Well, hasn't the Court of Appeals already kind of construed the contract? I mean, it really, if it went back to the trial court in the present posture, there's a pretty strong signal from at least the Court of Appeals what it thinks the easement means, right?
I think yes. I mean, I think the 7th District. I think that's dicta, and I don't think that
should we vacate that part of the decision?
I think I'm in front of the 7th District a lot, but yes, I think that yes, it should be vacated. I mean, I think they went too far. I think it created confusion here. I honestly don't think this would be on appeal if the 7th District hadn't gone that far.
Okay,
and basically, because Judge Hervey would have no choice. He'd have to rule that phrase was ambiguous or else he'd get overturned on reappeal.
Okay. Let me, I'm trying to figure out this comma argument. So as I understand it, your argument is because there's not a comma between cut and remove, that cut and remove go together. So it's trim, cut and remove, right? Is that?
Sort of. So it's trim, remove, cut, remove are the two phrases.
Wait a second. How do you get trim remove out of that? I mean, if we adopt your construction and say, well, because there's no comma, cut and remove go together, how does remove apply to trim?
So because it uses and it's
right. Cut, trim, comma, cut, and remove. So there's two possible ways of reading that. One, there are three different things, Or secondly, there are two things: trim, cut, and remove. I mean, you can't have it both ways, right? You can't say that the lack of a comma means that and remove modifies cuts, but then say it also applies to trim, right?
We actually believe it
At
does.
least not
I think that's
any
what-
grammar that I've ever heard.
We believe it does, and we think that's what the 7th District ruled, was that the cut and trim are both augmented by remove. So cut, remove, trim, remove.
Well, but either, I guess, argument about the construction, what about the harm or damage that is allegedly done by use of herbicides, leaching? So I don't, under either interpretation of trim and remove, cut, remove, trim, cut, remove, how does that abate the harm of leaching?
I think the main point, Justice Stewart, is that we don't believe herbicides fit under either of those two definitions. Accordingly, there is no right to spray herbicides on the property at this point.
So
That would be
what, so does it matter how trim, cut, and remove, or trim, cut, and remove is interpreted? I
we
mean,
would
does
say
the use of herbicides fit into one of those definitions more than the other?
we don't believe so, because it's if you use a herbicide, it's let's say it's disjunctive and there's three rights there. We don't believe that using a herbicide is trimming. We don't believe it's cutting. And we certainly don't believe it's removing, because you don't remove anything when you do that. You just spray it, it partially dies, comes back, they reapply. And so we don't believe.
And the dead foliage or the dead stuff stays on the property?
That's correct. Yeah. They just spray it and it stays on the property. So there is no removal ever in that situation. So even if the court were to hold that they're disjunctive, there's three rights there, we don't feel like it falls under any of the three.
Thank you.
Counsel, is there an argument that, I mean, I know your clients do not want the herbicide on their property because of health concerns. Is that fair to say?
I mean, I think it's twofold. I think it's health concerns, but I also think it's, this is an easement. This is a property right. And this is very, very important. And basically, if the court extends this right beyond what the parties agreed to, it's basically a taking without compensation. So I think it's twofold. But health is definitely, I mean, we're talking about.
Okay, but the herbicide that is used is not banned in any way by either state or federal regulation?
Not yet, but it's been found to be cancer causing in recent cases.
Okay, but to answer my question, it's permissible as part of their vegetation management plan, correct?
Under their yes, I think it is permissible under the vegetative management plan as it currently exists.
Okay, and if this becomes the law in, if we send it back and has basically the same result in the trial court, the 7th, affirms it, then that's the law in the 7th district, correct?
Yes. Okay,
so then we have a patchwork around the state, or at least around the service area for the appellant's service area, which then will be, of course, duplicated in other utility service areas. Where's the continuity that was meant to be established through the operation of the PUCO and the planning of the PUCO to be applied statewide?
Well, I think that what you have to do is you have to look at the easement language. And so I think that this court's holding will teach us further whether or not the trial court gets the first bite at the apple on this kind of dispute. I think that's the key here. The second key is that if the trial court determines factually, and this court doesn't rule on that the vegetative management plan or that this easement does not cover herbicides.
All right, so do we go back to 1948 and find out what they used to clear a brush in 1948? Because they probably burnt it at that point. Is that permissible that PUCO, or excuse me, that Ohio Edison comes in and torches the area in order to create vegetation management?
We would object to that. I mean, it's not trim, cutting, and it's not removing.
Okay,
It's burning.
what about if they say they want to dig something up so it doesn't come back? Let's get it out by the roots.
I think that would fall under trim or cut.
You think-
I mean, I think that's,
Well,
you're talking
well,
about cutting the root system out.
No,
So-
no, pulling the root system out. What if they say, you know what, we're going to hire some kids and go pull weeds?
I think that falls within trim and cut, and you're removing it.
It's not trimming, it's not cutting. You'd have to be
Removing it.
removing, right?
I mean, you're still cutting through the ground. You're still pulling something out of the ground. I would
And-
argue that still falls into trim, cut, and remove. But I think at the same time,
Well, counsel,
that-
didn't you say when I asked you previously, if you pull a tree out by the roots, we were using that example, the difference between cutting off a limb and removing it by pulling it out by the roots. Isn't that similar to what Justice DeWine just asked?
I mean, I think so. I still think that's trim, cut, or remove. I still think you're removing it. You're trimming and
You're
cutting
removing
it.
it, but you're not
You're
trimming it or
removing
cutting
it.
it.
You're removing it. You're not cutting it. You're
No,
not trimming it. You're removing it.
I mean, so the hypothetical though is that you would get every piece of root, and if you've ever pulled a tree, I think that it still would fall under trim or cut, because I think you have to trim or cut something to get a tree out. And I think you kind of go to the whole thing about also, are they in breach when they mow the grass and leave the grass on the ground? I mean, because they don't remove it. But I mean, that isn't spraying herbicides on the property. That is trimming and cutting. So for the foregoing reasons, we respectfully ask the court to affirm the 7th District's decision, and that the court to hold that the Court of Common Pleas has jurisdiction over this matter, and to decide the parties' dispute. Thank you for your time.
Counsel, you have about a minute and a half left.
All right, thank you very much. Justice DeWine, I think I finally understand your question. And this is, after all, an appeal of summary judgment. So it's de novo. It's also de novo on the jurisdiction issue. So this court would have the ability to rule, and I would agree on that. This record stands before you as unrebutted, and the questions were asked about the dangers. Unrebutted in this particular record that's before this court is Sam Quattrochi's opinion that this is how the industry is doing it. This application is safe. This application doesn't harm animals and other compatible vegetation that will grow, and that the PUCO has approved it, and that this is consistent with the plan. If we start parsing, is this a cut? What is this modern method, and how does this work? We are now invoking, we're into the specialized expertise of the PUCO, and that entire uniformity that's been set up is null. And the utilities need to be able to use the most modern methods, especially after the blackout, the PGM, the fires, in order to ensure adequate facilities, and that includes vegetation management.
But to say that use of herbicides is completely safe, it's not harmful to other vegetation, it's not harmful to animals, shouldn't there be an opportunity to present that and have it adjudicated before a court?
Well,
before a finder of fact?
this is a summary judgment motion, and for whatever reason, that evidence is unrebutted in the record that now is de novo before this court. There's no evidence to the contrary, and the judicial, take judicial notice issue, was waived, we believe, and it didn't look at exactly what's being done here. We have an affirmative opinion that's unrebutted that it is safe. It's not going to leach. Sam Quattrochi covered all of the concerns, Justice Stewart, that you've put forward in this application. So this record is complete. And ready.
Wouldn't those be questions for PUCO? I mean, whether or not they're using the right herbicides or the amounts, and I mean, aren't those the kind of questions that we have said are in the PUCO's exclusive jurisdiction?
They are, and everything I just said is assuming, because it's the alternative argument, and assuming that you didn't agree with our first argument.
we could agree that it's the court's power to say yes, remove includes using herbicides, but beyond that's a question for the PUCO. Wouldn't that be a reasonable way to look at this?
Yeah, absolutely. Would agree with that. That would preserve their specialized expertise to review this practice normally authorized by the utility and approved in the plan we submitted to them under 4901:1:10-27E, which was developed in 2000. So this is a more modern method. And no, we didn't do it before. We tried to do the least restrictive means. And Roy Maldonado pointed out what's happening. Those brushes are coming up. And the engineer said, this interferes with the line now and has to be removed. I believe I'm out of time unless there's.
I asked one more question. There was no brief in opposition filed to your motion for summary judgment at the trial court?
There was a brief in opposition. However, there was no record evidence, no affidavits, nothing submitted. And it was cross motions and then cross oppositions.
The brief in opposition just alleged that there was an issue of fact, but didn't contain any evidence?
That's correct. There's no record evidence that was submitted in opposition.
Okay.
Thank you. Thank you. The matter will be taken under advisement. You'll be notified of our decisions. Our next case is 2019-980, the State of Ohio versus Ursula Owens. For the appellate, Mr. Sweeney.
Thank you, Your Honor. Chief Justice O'Connor, members of the court, if it pleases the court, I'm Tim Sweeney from Cleveland on behalf of Ursula Owens, and if I could please reserve 3 minutes for rebuttal. This is a sad and tragic case of a young child. It's a terrible death. And as a result, we have a 37-year-old woman with no criminal record who's now in prison, perhaps for the rest of her life, for a homicide which the jury unanimously determined was due to her recklessness and was not purposefully caused, rejecting 2 of the 3 homicide offenses charged by the state. Now we're here because Ursula Owens was denied her constitutional right to have her jury determine whether that 3rd homicide offense, felony murder B, so-called murder B in Ohio, was also a case of reckless homicide and not that greater offense. As courts throughout Ohio have for many years permitted juries to do in cases like this and still permit. So the issue here is whether reckless homicide is a lesser included offense of murder B, where felonious assault of the victim is the only predicate. And the answer to that is yes. And the lower court was wrong in holding otherwise. And this court should reverse and send it back. The Dean test has 3 elements, 3 requirements. Only one of them is really an issue here. The first one isn't an issue. It's whether the greater offense here, felony murder, carries a greater penalty than the lesser one. It certainly does.
Mr. Sweeney, before you continue down the substantive analysis, was this error preserved?
Yeah. Oh, yes, it was, Justice Stewart. Yes, it was. Well, I mean, the issue was raised. They asked for the instruction. The trial court gave the instruction only with respect to counts 1 and 2.
And so then was there an objection that it wasn't given with regard to the felony murder count?
No, there wasn't an objection on the felony murder count, and it was preserved in the appellate court below by virtue of the assignment of error concerning the ineffective assistance of counsel for failing to ensure that instruction was given as it should have been given.
So preserved for our purposes at
Right.
the appellate court level through the ineffective assistance of counsel through the IAC argument.
That's right, Your Honor. That's correct.
And the 8th District disposed of that, or really didn't address it because of their holding that the substantive holding that is now a lesser included offense of felony murder.
That's correct, Your Honor.
Okay, thank you.
Yes, that's correct.
Mr. Sweeney, at the trial court level, did the trial court judge provide any explanation on the record as to why it was warranted in the other two counts, but not warranted for this count?
No, Your Honor, that wasn't addressed. I mean, it was a very brief colloquy in the jury instruction here in this case. The defense asked for the reckless homicide instruction. They weren't as precise as they should have been in requesting that it be as to all three. The state objected to the instruction. Their argument was this simply isn't a case of recklessness, and they did not want the instruction given on any of the counts. The court, after a short discussion, said, I'm going to give the instruction. And then, in fact, did give the instruction, but only as to counts 1 and 2, which were the aggravated murder counts. The aggravated murder count, prior calculation and design, and the aggravated murder count because the victim was under 13. The court failed to give it as to the murder B count, which is where it most certainly belonged in this case, because this case squarely presented this issue of recklessness.
This was the felony murder count?
Felony murder, yes, Your Honor, is count 3.
With predicate felony being felonious assault? Is that?
Yes, correct. The count 3 and 4. Count 3 was the felony murder B with felonious assault, count 4, as being the sole predicate, the felonious assault of the victim being the only predicate. And so it's interesting because if you look at the record, the trial counsel, the defense counsel, in arguing for the Rule 29, actually made the argument that felony murder B is this knowing mens rea. He made that argument. It's on page 1703. So the issue was there.
Well, knowing as to what? Isn't that the question?
Well, Your Honor, I think the
No,
answer is
what is the element that has to be knowing for felony murder?
you have to knowingly cause the death.
No, that's not true, is it? Right?
Nope, I don't agree with that. I think the law is clear that the element of the culpable mental state.
Doesn't the knowingly element apply to the physical harm?
The knowingly applies.
The felonious, the elements of, I mean, felony murder requires that someone be committing another felony and murder result. So what has to be knowingly is the physical harm, right? Isn't that what felonious assault requires?
No, I think that's wrong. I think that
felonious assault doesn't require knowingly causing physical harm?
Felonious assault does.
Okay,
yeah.
so you can commit that felony by knowingly cause physical harm. And if you commit another felony and a death results, that's felony murder, right? Correct?
The doctrine of felony murder incorporates that predicate mens rea into the murder. And so for all relevant purposes in this case, that knowingly element jumps in to that clause of the offense. It is improper to disregard that because that's the whole purpose of felony murder. And the court.
So there really is no felony murder when it comes to felonious assault then, because it's just knowingly, it's a murder. It's knowingly causing a death, right?
No, I mean the offense is called felony murder, Your Honor, but the mens rea comes from the back end of the offense. It seems to me, that's been the law for a century.
Well, counsel, isn't it either you have the mens rea to commit the felonious assault, or you have, and if you do, then obviously that's the offense. But are you saying you have the mens rea to commit felonious assault and you also have a mens rea to commit felony murder?
Yes, it's a fiction, but it's a legal fiction. The courts are required to recognize. And
well, if you have the mens rea to commit a murder, you don't need the felony, do you? You've just been guilty of murder.
Well, the crime you're guilty of is felony murder by virtue of knowingly committing an offense that's defined in the statute. And the statute must be read consistently with the common law, which this court has even said, I believe. It said it in a number of cases that the predicate offense contains the mens rea element for felony murder, which is why, Your Honor, you see courts even today still instructing juries that you must knowingly cause the death in a felony murder B case, because knowingly is the predicate offense, period. It's all fictional to talk about whether it's at the back end or the front end. It's a knowing offense.
Was that instructed with regards to the felony murder count? Was a mens rea instruction provided?
Well, that's the point I was trying to make before, Your Honor. It was not. I mean, a lot of courts simply say in the instruction, cause the death of another as a proximate result of the felony. Other courts say knowingly cause the death of another as a proximate result of that knowing offense. Both are right. But when you
felonious assault was in the instructions in this case, the elements of felonious assault, including the mens rea element, was included in the instructions of that particular count, right?
Well, yeah. I mean, in the fictional sense that you have to be able to establish the knowing element on the back end of the offense. Okay. Many courts, and I would argue this is the more appropriate and correct way, is to put the knowingly word in the front, knowingly cause, which is why, for example, I cited in the supplemental authority the Bay case out of the 9th District, because that's the way they did it. And they said, that's right. That's the way the jury should be instructed. Knowingly cause. It may be a fiction, but it's a fiction that needs to be indulged because it's so darn important that people who are charged with an offense like this have the jury be given the chance to determine whether their culpability is consistent with their conduct. This offense brings a life sentence. Think about that. And as a result, the jury needs to be able to assess whether the conduct is knowingly caused, which would be deserving of a harsher punishment, as opposed to recklessly caused when it isn't. This case presents this issue. This isn't a legal, hypothetical law school type issue. This is a real issue because this is the case where the jury said the conduct is reckless. They said it in 2 different verdicts. They assessed the homicide here as the result of recklessness. Think about that. That means this was a reckless homicide. It wasn't a knowing homicide or a purposeful homicide. It was a reckless homicide. And that's the issue that is so important here, that ought to be of concerning to this court, because this woman now is serving a life sentence because of something a jury determined was the result of recklessness. That's not right. That's not correct. That's not what the law permits. And the lower court here, Your Honors, disregarded the essential notion of what felony murder is by saying you don't really have a mens rea here. You do. It may be fictional. It may be something you have to think through a little bit, but it's there. And the mens rea, when felonious assault is the predicate, is always going to be knowingly. And when a jury is instructed, they should be told that. But if they're not told that, they still need to be given the opportunity to choose that lower count, that recklessness count, if the facts permit it. And this case does. And this is important because of the need to preserve that hierarchy, it seems to me, the hierarchy of these mental states: purposeful, knowing, reckless. This is reckless. Recklessness is less culpable than the most harsh penalties of murder. And that's why I cited this Eli case out of Tennessee. I would encourage the court to take a look at that. I know I cited it later. It was in the supplemental authority, but it's a very helpful case. The Supreme Court of Tennessee looked at this very issue and applying the same types of analysis our courts apply when they look at this issue. And they concluded that, yes, indeed, reckless homicide, these other lower offenses of murder are a lesser included offense of felony murder, because it's necessary to do that to keep in mind the different levels of culpability. Somebody who's reckless is less culpable than somebody who did something knowingly or who did something purposefully, and they're therefore deserving of a harsher punishment. Due process requires that. If there's no questions from the panel, I would reserve the rest of my time if I could, please, Your Honor.
Yes, thank you. Is it Pateo?
It is, Your Honor. Thank you. Chief Justice O'Connor, and may it please the court, Brandon Pateo with Cuyahoga County Prosecutor's Office on behalf of Appellee State of Ohio. In this case, Your Honors, the court should affirm the conviction of appellant for 3 reasons. First, This issue was not properly preserved at the trial court level. There was no specific request for the instruction of reckless homicide with regard to the third count of the indictment. And when the jury instructions were provided, there was no objection lodged. That's why the transcript in this case does not provide much explanation as to any of the decisions made.
Well, Counselor,
All
but there was a request for the instruction generally, correct?
Correct, Your Honor.
The request for the instruction was not specific to just counts 1 and 2.
It was a general request.
So why wasn't the general request sufficient?
It might have been sufficient if they weren't seeking it now or if they didn't seek review of it. However, at the time the instructions were read, there was no objection made. Therefore, they have waived all but plain error. Had they lodged an objection when the instructions were made, the trial court could have made a record of its findings, its reasoning. Counsel could have placed on the record the specific reasons that they would request it with regard to that count.
What about the fact that the essence of that, the substance of that assigned error was not reviewed by the Court of Appeals?
The assigned error was not reviewed with regard to that because of the 8th District's decision. The 8th District ruled in the lower decision that reckless homicide is not a lesser included offense. So they didn't get to the question of ineffective assistance.
So if we were to disagree with that outcome, then is that assigned error or the error with regard to not having the instruction on the felony murder properly before us? Would we have to send it back to the Court of Appeals to address the issue in the first instance?
No, Your Honor, I don't believe that's required for multiple reasons. First, the fact that the jury properly convicted appellant of the more egregious offense of felony murder, that is, the manifest weight of the evidence supported the conviction for the greater offense in this case, there is no harm to any error in not giving the instruction.
And so you're saying that the court found that reckless homicide is the underlying offense to felony murder?
The lower court specifically found that reckless homicide is not a lesser included offense of felony murder.
But what's the felony that then resulted in the felony murder?
The felony is the felonious assault.
Felonious assault. Okay.
That is count 4, in which the jury also found appellant guilty of knowingly causing serious physical harm to the victim, TM.
Can you have a felony murder and a conviction for felony murder and a conviction for reckless homicide? Is it intellectually sound to say that a death occurred by recklessness and then a death also occurred by intent?
Yes, I believe that that's intellectually sound, but I think that, and that is the core of appellant's argument in trying to impute a mens rea for the intent to kill within the felony murder statute, which does not include a mens rea with intent to kill. It is possible, under the facts of several cases, including potentially this one, that a jury could convict of both of those offenses. That being said, the 8th District's reasoning is sound. But before I get to that, I would like to address the additional reason that counsel's failure to object to the lesser included would not be an effective assistance. That is that under this court's holding in State v. Griffey, it is a trial tactic and a matter of strategy whether or not to specifically request a lesser included offense to any particular crime, whether or not that lesser included offense is available. In this case, the trial court and the trial counsel, therefore, could have made a tactical decision not to request this particular count. We don't have a record of that at this point, but that is.
I would agree with you on that point, counsel, but under our current case law, the trial court judge, sua sponte, if they believe the evidence supports something, could add that instruction on their own without it even being requested by either party, correct?
That is correct, Your Honor. The trial court could have made that decision. The trial court did not make that decision, and the trial court did not err by not making that decision, because the facts of this case under State v. Trimble would not support an acquittal of felony murder where they also could support a conviction under the reckless homicide. This was a case in which appellant was convicted of the predicate offense of felonious assault. That felonious assault was the serious physical harm of the victim TM. Based upon the knowing mens rea in that offense and the proximate harm caused by that offense, which included body slamming the 5-year-old victim multiple times into both a wall and a dresser before she was rendered fully unconscious, that would amount and did amount to felony murder. The fact that the manifest weight has been upheld in this case, but the evidence did support this conviction, also supports the fact that there was no change in the outcome of the case based on the lack of instruction for reckless homicide. If I could address the 8th District's opinion below, it does follow the statute for 290302B and this court's reasoning in Miller, Fry, and Nolan. 290302B, felony murder in the state of Ohio, does not include any mens rea for intent to kill. This court has repeatedly discussed in each of those cases that the mens rea comes from the predicate offense. So in this case, the only mens rea that the jury was asked to consider appropriately was whether appellant knowingly caused serious physical harm to the victim. The 8th District reasoned appropriately that based on this, felony murder does not ask a jury to consider whether or not there was any mens rea with regard to intent to kill. This is the distinction under Deem that the 8th District made with regard to reckless homicide, which specifically includes within the charge that there is a mens rea. So the jury, when considering reckless homicide, is asked to consider the knowledge of the actor with regard to intent to kill. This is a key distinction, and it follows this court's logic. Appellant relies on State v. Trimble. State v. Trimble was a case in which this court considered whether reckless homicide is a lesser included offense of aggravated felony murder. The key distinction between aggravated felony murder and felony murder for our purposes today is that aggravated felony murder includes a purposeful mens rea, and that's purpose with regard to intent to kill. This is the distinction where this court in Trimble appropriately held that reckless homicide is a lesser included to aggravated felony murder. This court can today hold appropriately that the 8th District is correct. Reckless homicide under Deem is not a lesser included offense for felony murder, 290302B.
Counsel, is there any support for your Mr. Sweeney's position of the, I guess he called it a legal fiction, the transference of the mens rea that is required for the predicate offense? There has to be a separate mens rea for felony murder that would replace what is traditionally, and I think based on precedent, a strict liability offense.
I don't believe that his argument is supported. I think his argument depends on a misreading of this court's jurisprudence with regard to Nolan, Miller, and Fry. Within each of these cases, this court has previously held that, quote, the felony murder statute imposes what is in essence strict liability. It does have a mens rea, but it does not include a mens rea for the culpable mental state of intent to kill. The only mens rea included is that of the underlying or predicate offense. So in this case, there is a mens rea, But that mens rea is only asking a jury to consider whether or not there was a knowing intent to cause serious physical harm. It doesn't ask a jury to consider in any regard whether or not there was an intent or a reckless intent or any mental state with regard to causing death or intent to kill. And that's the distinction here, where the 8th District has decided upon this court's jurisprudence and a plain reading of the statute in which the General Assembly chose to not include any mens rea for intent to kill. Regardless, however, of whether this court agrees with the legal reasoning within the 8th District's opinion below, this court should still affirm appellant's conviction because the facts of this case do not support reasonably both an acquittal on the greater charge of felony murder, where there would be a conviction of the lesser charge or what would be a lesser charge of reckless homicide. For a jury to reasonably convict appellant of reckless homicide, that jury would also, upon these facts, need to convict for the greater offense. That's been the outcome of each of these cited cases by appellant and by the state, in which previously district courts have found that reckless homicide was a lesser included offense of felony murder. In each of these cases, including Alston, which this court cited in Trimble, felony murder was determined to have a reckless homicide lesser included. However, the lower courts did not find any error where the facts in those cases did not support both an acquittal on the greater offense and a conviction on the lesser offense. And that's the case here, Your Honors. We have a conviction in count 4 for the felonious assault. Additionally, the death of the victim was caused based on the testimony of 2 state's witnesses related to the autopsy, as well as to the treating physician at the ER, based on the serious physical harm from the trauma that she faced on appellant's physical abuse. Again, beyond all of these questions, should this court determine that the 8th District was legally incorrect and that factually appellant was entitled to a lesser included instruction, there was no harm here because the manifest weight of the evidence supports the conviction for felony murder. The only case cited opposing that view is Beck v. Alabama, which is specifically a death penalty capital case, and the reasoning of which does not extend to this case, which was not capital, did not involve the death penalty, and in which harmless error analysis is appropriate. And that's State v. Elwell as well. 9th District has supported that view. I would also like to address the conflation between the decision of the jury in counts 1 and 2 for the purposely mens rea and count 3. Count 3, of course, was the felony murder. Appellant has argued at length about the jury's decision not to convict with regard to the purposely element of counts 1 and 2, as though the decision that the state did not meet its burden with regard to purpose was a decision that the state would not have met a burden with regard to knowingly. This is not the case. The jury was not asked to consider a knowingly mens rea with regard to intent to kill in counts 1 and 2. This is distinct from count 3. And additionally, under the reasoning of the 8th District and this court's prior jurisprudence, the third count did not require the jury to consider any mens rea with regard to intent to kill. Pending any further questions, I'd respectfully request that this court affirm the lower court's decision and the conviction of appellant.
Thank you. Mr. Sweeney, you have a little over 2 minutes. You'll have to turn on your microphone.
Thank you. Sorry about that.
Counsel, I'd like to hear a response to your colleague's arguments about Miller, Fry, and Nolan. He's basically saying we have to overrule them to agree with you.
I don't think that, no, absolutely not. In fact, I think my view of those cases is they support this argument. Nolan, first of all, the question there is whether attempted felony murder is an offense or not. That, and the court did make the observation that it's in essence a strict liability offense. I don't view that as anything other than dicta. The principle of an attempted felony murder was rejected as being an offense in Ohio because there was no murder in that case. And because there's no murder, you can never have the imputed intent to commit murder, which only happens in felony murder cases. That supports this notion here too. And the court in Nolan, in fact, specifically cited that doctrine of imputed intent. That, just Chief Justice O'Connor, is where I think some support for our position comes from. It comes from this court's own recognition in Nolan of this basic tenet. That's the court's term. A basic tenet of felony murder is that the intent is imputed from the back end to the front end. And that's why, so when the court says in Nolan, there's no offense of attempted felony murder in Ohio, yeah, maybe so, that's true, because there was no murder. And when there's no murder, there can be no imputed intent to the front end to make the murder a culpable murder.
But it did reinforce using the word strict liability describing felony murder, and you say that's dicta, but what you just said, that they imputed the mens rea from the back end to the front end, is not dicta?
That's, Your Honor, that is the essence of the common law offense. That goes all the way back. I think we cited a case from Justice, not yet, but a Justice Frankfurter, I think in one of our, from the 20s was cited in our briefs. This is a doctrine of the common law. And we did cite Morissette and other cases from the US Supreme Court, which says that when you have these offenses, even in state offenses where they are defining crimes, you're going to look to how the common law defines that crime too, when it's a crime that comes from the common law. Felony murder comes from the common law. The notion of transferring the intent from the back to the front is the essence of the crime. That is always going to be true. I want to address the argument here that there's some sort of harmless error. I think that's absolutely wrong. The error here is just so basic and so fundamental. The jury should have been given the chance to decide whether this was recklessness or something worse, and they didn't get that chance. It's always going to be the case when you come into court like this, arguing that you should have gotten a lesser included offense on felony murder because your conduct was reckless. It's always going to be the case that they would have already found it knowing, because that's the requirement of the statute. They had to find, as even under the count 3, they had to find that you knowingly committed felonious assaults. You're always going to have had that baked in the cake. It's always going to be the case. So it doesn't matter that the jury found that here. The point of the matter is they never had the chance to decide whether it was something less, whether it was recklessness, and they should have been given that chance. That's such a fundamental thing here.
What are the factual basis contained in the record that you believe supports reckless behavior as opposed to knowingly?
Well, I mean, first of all, Your Honor, and I don't mean to say this glibly, but that's what the jury found. They found it to be reckless. And I think
on the other two, with a higher degree of
right, but nonetheless, they concluded it was reckless conduct, and they rightly concluded that. There was a lot of facts in dispute here about whether there even was anything seriously assaultive that morning, and whether these women were confused about whether the girl was suffering from a seizure or not, and they were Googling to see if, whether the seizure, how it would resolve itself. There was a lot of disputed issues in this case about what happened here and how it happened and why it happened. And there's a lot of grounds for a jury to say this was recklessness. It's tragic, but it's reckless. And that's exactly what they did find when they were given the chance to do so. There's no reason to assume that if they had not had given that chance on that felony murder count, they would have done the same thing, because that's what this case was. It's a sad, terrible case with emotional, very sad facts. But when the jury had a chance to sort it out and hear from all these different witnesses, they concluded this is a case of recklessness. That's the level of culpability.
Thank you, counsel. We'll take the matter under advisement, and you'll be notified of our opinion, our decision. Marshall, will you call a recess, please? The court is in recess.
Thank you, Your Honor.
Thank you.
Taking time for some reason. Good morning, Chief Justice O'Connor. Can you hear me?
Yes, I can hear you. All right, let me call the case.
Thank you, Your Honor.
2019-1123, Timothy Garrity versus John Chervenik, trustee of the Chervenik Family Trust et al. For the appellant, we have Mr. Matthews.
Good morning again, Chief Justice O'Connor, members of the Ohio Supreme Court. My name is Jim Matthews. It's a privilege to be here this morning on behalf of the appellant, Mr. Garrity. Chief Justice O'Connor, I'd like to reserve 3 minutes for rebuttal, and I know it is my responsibility to watch the time. This case brings once again before the court the Ohio Dormant Mineral Act for consideration and application. The question in this case, distilled to its essence, is really the import of the 2006 amendment to the Dormant Mineral Act. When the General Assembly reconsidered the Dormant Mineral Act in 2006, a large portion of the 1989 version of the act was reenacted, including some language that we're going to get to in a moment. But the General Assembly also then incorporated a notice and service provision that is sort of the heart of this case. The court held in the Corbin case, as well as a few cases following Corbin, that the 1989 enactment fashioned an evidentiary presumption to address the issue of burden of proof with respect to intent to abandon in the Dormant Mineral Act context requiring a quiet title action to be timely pursued to capture that presumption. The question then rephrased in this case is, did the 2006 amendment displace this process in its entirety, applicable to every fact scenario, or did it do something less? We have to remember that the notice and service provision is an extrajudicial process, meaning it purports to operate without judicial supervision of any fashion. So it's our position that our propositions of law support the latter position, that the notice and service provision added into the Dormant Mineral Act by way of the 2006 amendment only created an extrajudicial process applicable in limited circumstances. The restricted operation of the notice and service provision in the 2006 DMA is, in our view, applicable only when a surface owner is able to identify all of the holders of a severed mineral interest. We have addressed in the briefing the principal basis for that view, and the view is, as addressed in our first proposition of law, based upon a strict application and simple reading of the words used by the General Assembly in the statute itself. We start with the application of the word holder. Holder is expressly defined in the statute not to simply be a record holder of a severed mineral interest. To the contrary, it's much broader than that. A holder means the record holder of a mineral interest and any person who derives the person's rights from that record holder. As applicable in this particular instance, that is the appellant, Mr. Garrity. Mr. Garrity, as the record reflects, derived his rights from his mother upon his mother's passing. And as a result, he qualifies as a holder for the application of the statute in this instance. The appellee, through the briefing beginning in the trial court, fully acknowledged Mr. Garrity was a holder, and the Court of Appeals has recognized Mr. Garrity as a holder. I don't believe the issue is disputed. We then have to take a look, before we address the service issues, at utilization of the notice provision and what is required to be expressed or contained in a notice. And I believe this is critical to the analysis. I know that service is important and we're going to be talking about publication and such, but before one even gets there, one has to look at section F and determine what needs to be in a notice to begin the process. The statute is again very clear. Under F, the notice required under division E1 shall, meaning it must, contain all of the following: the name of each holder and the holder's successors and assigns as applicable. By utilization of the word holder in F, it broadly means that you have to identify in your notice each holder, not just each record holder, but each holder or any person who derives their interest from the record holder. Our position in this case is that in light of these two provisions of the statute, the surface owner was required, in order to utilize the notice and service provision, to identify the appellant Garrity and include the appellant Garrity's name in the notice for the attempts at service.
What if you can't identify all the holders?
Your Honor,
say someone has 8 kids. Say each of those 8 kids has a number of children. You can't track them all down.
If you cannot track all of the holders, then you have to resort to a judicial process, not the extrajudicial process, to try and capture the dormant or severed mineral interest.
So unless you can figure out everyone that this may have passed to, you can't use this process at all?
That's correct. That is a strict interpretation from a direct reading of the words used in the statute. If I may, I'll digress on something, Justice DeWine, to address that a little further. Again, when I started my presentation, I mentioned how the 2006 enactment included a reenactment of many of the provisions from the 1989 law. One of the key provisions is in B itself. B says that the same words are used as the 89 version. A mineral interest shall be deemed abandoned and vested. If we apply Corbin and continue it through in a logical extension, that merely creates the same presumption, an evidentiary presumption, that can be pursued through a quiet title action. If you do not know all of the holders of an interest, you can still, and quite frankly, you have to resort to a judicial process to seek to reunite the minerals. We believe that's the only due process safeguard that can be applied the way this statute is written.
Counsel, I wonder if we could focus in on the language at 5301, 56E1.
Yes, Your Honor.
That says that a surface owner has to serve by certified mail each holder or each holder's successors or assignees. How would that phrase make any sense if successors or assignees are also holders? Doesn't that?
Your Honor, it only makes, yes, Your Honor, it only makes sense by looking at the inclusion of or each holder's successors or assigns as mere redundancy. There's no import to that clause being in subsection 1 of E. The reason is, again, the clear definition of holder. Holder itself, by definition, already bootstraps not only the record holder, but anyone taking through that record holder, which would include successors and assigns. So quite frankly, by using holder in there, it is unnecessary and superfluous to have or each holder's successors or assigns. Holder means everybody that has taken the interest.
Just as a practical matter, in how many of these situations would you guess there are multiple successors or assignees?
Statistically, I can't give anything on that. I could tell you from experience that it varies greatly. This is a unique fact pattern that is in front of you where the record demonstrates a single heir to a record holder's interest.
Well,
I do realize
that's kind of my point, is that
yes.
This seems highly unusual. And if that's the case, I mean, did the General Assembly just make a mistake that they thought they were creating a process that would apply in most situations, when really this isn't going to work in most situations if we accept your argument?
Yeah, and let me acknowledge what you're stating, Justice French, that indeed there are other fact scenarios where there are multiple segments or fractionalization of the interest. I appreciate that. But then again, it's our position that the way the statute is written, you cannot take the benefit of the extrajudicial process to reunite that mineral. You need to fall back on the other language of the statute, apply Corbin, pursue a quiet title action, and utilize those protective measures so that a court is overseeing in order to carry out the process.
Why is there a provision for notice by publication in here?
Well, I believe that that's only if an attempt is made after the identity of all holders is known, an attempt is made to serve at each of the holders at a last known address. And as the statute says, you're not able to serve any of those holders. Then you can proceed to the publication.
So under your understanding of the statute, you would only use you'd only use notice by publication when you know who you want to notify, but you haven't been able to serve them by certified mail, but you know these people.
Right. The statute uses the word complete, I believe. If you're unable to complete the service.
So would this notified publication include their names? Like, hey, Bob Smith, I know you live in this town. You're not opening the mail.
My position is, Judge, it must. And again, that's because of the wording that's directly contained in F. F requires that the notice identify each.
Wouldn't that be kind of a different way that the legislature has used notice by publication than in any other context?
Well,
to notify someone you know who they are?
Well, I don't believe it's that significantly different. The only distinction, as we've addressed in the briefing, is a revised code section that addresses service of process, again, with court supervision, when you're unable to identify a defendant in a legal proceeding. That's what we believe is most analogous to this situation. And that would be applied either by inferring or applying that standard to the Dormant Mineral Act as written, or requiring a party who is not able to identify all of the holders to proceed with a quiet title action, take advantage of the presumption, the evidentiary presumption that's created by the language deemed abandoned, and then have a court endorse after an affidavit is filed showing the due diligence undertaken to identify all holders to proceed with publication under the statute. We believe that is the way to have all of these statutory provisions unite and carry out due process when you're dealing with an attempt to abandon what may well be a very valuable mineral interest that someone owns. If you just apply the notice and service provision of the Dormant Mineral Act in a loose fashion, elevating, if you will, form over substance, I submit you're going to have unjust results. You are going to have what has been expressed by some of the amicus, where people are only making bare bones effort to locate people in no real effort to attempt a real effort at service so that you can publish as a formality and proceed to try and capture it by a recording. We don't believe that is how the statute should be interpreted in this case. And Chief Justice O'Connor, I see that I'm into my rebuttal time. If there are no questions, I would like to reserve the balance.
Thank you. Thank
Thank
you.
you.
Mr. Dortch? You'll have to turn your microphone on.
Thank you, Your Honor. Madam Chief Justice, may it please the court, my name is Michael Dortch. It is my honor to argue this case on behalf of the John and Gloria Shervanack Trust and John and Gloria Shervanack. Your Honor, before addressing the argument I prepared, I'd like to address the argument that I just heard, which I don't believe was actually made in the briefs. As I understood Mr. Matthews' argument, there is an additional mechanism here available to those wishing to reunite a mineral estate and a surface estate, but unable to do so because, as appellant reads the statute, section E1 requires service on each holder, and section F1 requires that notice to name each holder. Mr. Matthews suggests that there is then, if under his reading of the statute, when service cannot be completed because someone is unknown, that there is then recourse to a quiet title action without any effort, perhaps, to make service and comply with the statute. That just does not work. There is no common law forfeiture or common law abandonment, more appropriately. The only abandonment is that set forth in the statute, and that statute is clear. The abandonment and vesting of title occurs pursuant to section B of 5301.56. But then E expressly states, before a mineral estate becomes vested under division B of this section in the owner of the service of the lands, the owner of the service of the land subject to the interest shall do both the following: serve notice by certified mail, and of course, ultimately file notice of abandonment with the county recorder. So the argument that you just heard, I think, conflicts with the statute, and it attempts to incorporate some common law remedy that simply doesn't exist. Now, the true issue in this case, I think we all recognize, is pretty simply stated. Did the Shervanacks do enough to look for holders of the mineral estate at issue before they resorted to notice by publication? The answer to that question is also simply stated. Yes, they did. It is absolutely undisputed that the Shervanacks did everything the law states that they must, step by step, precisely in the manner that the law provides. Because they completed that process, as the General Assembly designed it, and because the completion of that process, or that process provided according to the 2012 statute, the title would then vest in the Shervin-Acts. At the time, a marginal notation was recorded on the deeds creating the original mineral reservation. That all occurred in 2012. Again, no question. There is nothing more literally for the Shervin-Acts to have done. Of course, the appellants dislike the result of the Shervin-Acts compliance with the statute, and therefore they've seized on this argument that the term holder includes successors and assigns, and they try to elevate that argument to, as you've heard, an argument that in every case, every single holder, successor, assigned, relict, heir, whatever, of an identifiable holder must be identified by name, located, and served service of process pursuant to Division E1. The problem with that argument, first of all, is it defies the intent of the legislature. It certainly creates a situation where the statute is pretty nearly useless in accomplishing the goal of that the legislature intended. And reading the statute in that way expressly conflicts with the General Assembly's express statement in statutory law 5301.55 that this statute should be liberally construed in order to accomplish the goals of the statute, and those goals are expressly provided. They are to simplify matters, they are to facilitate transactions, and they are to create reliance upon the record chain of title. Now, given those purposes, given that statutory mandate, and given the process designed by the General Assembly, the logical conclusion that we ask the court to reach is that the search that any service owner should undertake on behalf of a holder or seeking for a holder is a reasonable search. And that furthermore, it is reasonable to stop searching with the public record of the county in which the mineral estate is located, county or counties in which the mineral estate is located. Now, under that situation, under that rule of law, you are doing a number of things that all consistent with the language of the statute. You have created then an unambiguous test. Look in the public record, look at, I'm going to define, if I may, restate public record, and instead, because there are many public records, instead state the deed records, and I would extend that to the probate court, since frequently titles are transferred through actions of a probate court. But with that change, I mean, you are then creating a standard that is consistent with the language of the statute. It is unambiguous. It is easily applied by the courts, by developers, by landowners, by holders. It avoids inaccurate, unverifiable, and ever-changing sources, such as those that Mr. Matthews would have us rely upon, the internet, through what search engine, using what sites, with what search terms. These would vary in literally every single case.
So you haven't mentioned, you said look at the records where the mineral estate is located. Maybe I'm remembering this incorrectly. Did you not, you also looked in Cuyahoga County because that was her last known address. So would you also include in there records in the county where you have a last known address that the county doesn't match the mineral estate?
Your Honor, I would not. Obviously, that is for the court to decide, but I would not. I believe.
But you did that in this case, correct?
Exactly. My client in this case went above and beyond what I believe is the applicable appropriate standard. They searched the deed records of Guernsey County, Ohio. They had an address. They attempted service on that address and it turned invalid. They searched as well the probate records of Guernsey County. When they were unable to complete service or process by certified mail to the last stated address in the public record for the only known holder in the public record, they then did more. They searched the public record, they searched the deed records, the tax records, and the probate records of Cuyahoga County. Again, I apologize, I'm a bit loose with my use of the term public record. That search in Cuyahoga County was unavailing. It was a dead end. At that point in time, and for purposes of this individual case, I maintain the Sherman Act did what they were supposed to do. They complied fully with the statute. They went beyond what the statute actually requires, at least under the standard that I'm urging the court to adopt. And there was nothing there to lead them further. At that point in time, their search is reasonable, resort to publication is appropriate. Now, as I've said, they went farther, but I don't believe that the court should require that. And there's a couple of reasons that I don't think that the court should. The most important reason that I believe the court should not require the pursuit outside of the public record is because that's inconsistent with what the General Assembly itself said its purpose was. It wished to encourage reliance upon the title records of the counties. And it's a small burden for someone who values their mineral rights, who's aware of them, values them, and wishes to preserve them, to take any of the numbers of steps that the General Assembly provided that would allow them to preserve that right. They can file a notice of preservation. They can create a tax parcel for the mineral right, and the statute recognizes that. But if they don't take those steps, then they are creating the risk that their interest will be forgotten, or at the time that someone goes to try to evaluate the interest, that they can't be found. Well, that, I'm sorry, is a burden that should be placed on the holder of the mineral estate. It is not a burden that should be placed on the surface owner. And certainly, again, under the statute, the structure of the statute as it exists, we argue that that was one of the General Assembly's expressed intents. Furthermore, requiring some pursuit outside of the, I don't want to use public record again, but the deed and probate records also would encourage continued arguments over whether enough was done. And by creating a bright line test, the reasonable search required is a search of the deed records and probate court records. You can eliminate that later concern that, as here, somebody's going to come in and say, well, you didn't do enough in my particular case to find my particular interest in this particular mineral estate. As an example, the Fonzies, they are amicus briefs filed on behalf of the appellant here. The Fonzies have argued that, at least in their case, internet searches should be found appropriate because their surname is sufficiently unique. Well, I don't know that a test that affords the Fonzies, or for that matter, the Sherviniks, or a litigant named Dorch, greater protection than someone named Smith or Jones makes any sense to anyone. The court, I don't think, wants to require lower courts to decide whether the names Kennedy, Stewart, or Connor are more unique than the surnames DeWine, Donnelly, or French, or whether the surname Fisher is sufficiently unique only if it contains a C rather than lacks a C. So that sort of argument to me makes zero sense. But the most important reason that the court should limit this search to the deed and probate records of the county in which the mineral estate is located is because to summarize, it incentivizes holders to protect their interests. It promotes reliance upon the title records of those counties. It promotes the development of the natural resources by offering security and finality. It requires nothing outside the record. Requiring things outside of the record would do nothing to promote those interests, would encourage and permit further challenges, and frankly promotes litigation at any time, such as in this case, in which the litigation was filed some 5 years after the Sherviniks took title. And I see my time is up. I thank the court very much for its consideration.
Chief Justice O'Connor, am I back up?
You're back up. You have about 2.5 minutes.
Thank you, Your Honor. At the outset, I would respectfully direct the court to the provision in our brief addressed on pages 19 through 20 in particular, where we make the direct argument that dovetails our interpretation and application of the 2006 version of the Dormant Mineral Act with the court's decisions in Corbin and Walker. Our position is clearly articulated in there that when you cannot identify all of the holders and need to proceed to a judicial process as opposed to an extrajudicial process in order for the safeguards of everyone's interests, that it's no more burdensome to require a quiet title action to be pursued under those circumstances as it was under the 1989 version of the Act.
Counsel, Counsel, how did this property, how was it transferred to the Sherviniks originally?
By deed, Your Honor. It was a deed.
What kind of deed?
It was, I have it here, Your Honor, from the record. It is a warranty deed from a Robert Schaefer and Linda Schaefer. And by the way, I pointed out in the briefing, it's not necessarily crucial for this analysis, but the reservation that was created is expressed in the original deed to the Sherviniks.
Okay.
The final points I'd like to make is the balance of the argument advanced by the appellee, I don't believe is something that is appropriate for this court. I think it'd be better suited lobbying in front of the General Assembly for substantial changes of the Dormant Mineral Act, precisely along the lines of the act introduced last year, House Bill 100 addressed in the briefing, that would make the law coincide with the appellee's argument in this case. The General Assembly could rewrite, consistent with House Bill 100, the Dormant Mineral Act to provide a more restrictive definition of holder. It could define a holder as merely a record holder. It also proposed in that legislation, yet to be adopted, that record would be identified and that record search is all that would be required to identify a holder for service. Those are best left for the General Assembly to rewrite and not to impose upon this court an effort to struggle with the statute and rewrite the statute itself. Intent is evident from the plain language used by the General Assembly. F is clear. A notice before you begin the process must include all of the holders. You have to, at a minimum, exercise due diligence to find them. If that includes internet searches, you need to resort to that. And then an affidavit needs to be contemporaneously made to identify your efforts to identify these holders. We appreciate
Thank
your
you.
consideration of the case and
Thank you,
appreciate the
counsel.
time this morning.
Thank you. We will take the matter under advisement. You'll be notified of our decisions. Thank you, gentlemen.
Have a good day, everyone.
Thank you, Your Honors.
All right, our next case, our last case this morning is 2019-1221, the state of Ohio versus David Kastner II. For the appellant is Mr. Avery.
Thank you, Chief Justice. May it please the court, my name is Darren Avery. I'm here on behalf of David Kastner. As you're aware, the issue before the court is whether the 1993 definition in Taylor, State Ex Rel. Taylor v. Adult Parole Authority controls the meaning of that term is used in the 2017 amendment to Revised Code 292915 B1 C1. You've already heard the argument I put in the brief in the Nelson case, and that is roughly, I'll rehash it, that the legislature is presumed to be aware of this court's decisions, to know the meaning of the terms they use, to use the words, or to choose their words advisedly, and to know what they mean when they put them in statutes. If you combine those, they line up with Revised Code 1.42, which says if a word acquires a particular meaning, it should be construed to have that meaning, and those agree in supporting and support the position that Revised Code 292915 B1 C1, where it uses technical violations, means or has the same meaning as this court used technical violation in the Taylor case, and that is a non-criminal violation of parole in that case, but in this case, community control or probation. So that's the stock argument, or the basic argument, and I think it's controlling. The lower court said if that, not in this case, but in the Manna case in which they relied, they said, well, if the General Assembly had intended to if the General Assembly had intended that meaning, they would have said so. And my argument is that's exactly what they did say. They used the word, the phrase, or the term technical violation. And in construing that term, according to this court's precedent, you have to look to your prior use of that term. So that's, yes.
Let me ask you a question. I believe in the Nelson case, one of the terms was instituted by the probation officer as opposed to the court. In this case, the terms of community control that was violated by Mr. Kastner was imposed by the court. Is there a difference there? Is that a distinction without a difference?
It's not one that sorry, I'm getting some kind of feedback from time to time. It's not one that the statute, if interpreted according to the rules of your case law and the rules of statutory construction, would recognize. No, it's a term of probation, and the only distinction is criminal in nature, or
technical.
Well, technical would be non-criminal, but the statute then says technical or a bigger pool of violations, those that are crimes but not felonies. So
if somebody wanted to say non-criminal, couldn't they just say non-criminal?
Or they could say technical, because that's what this court already said. So they mean the same thing is the argument. But okay, and that's the I guess level one argument, but the one I included in the almost as an afterthought. This court has precedent saying that every term of community control has to be specifically tailored to rehabilitating the offender or establishing justice, something like that, administering justice and preventing future criminality. I cited that, and that is, State v. Healthy, 2004 case I cited in my reply brief. If every term is tailored to that purpose, then it's hard to see how under the alternative rule, that is the Manna rule, the 5th district, and I believe 12th district or 11th district rule, which says a specific rehabilitative requirement. It's hard to see how any term would not be non-technical under that rule and under that case. So in other words,
If we can look at the violations in this case, even under some of your proposed standards of what we should look at, your client was at Alva's house. He's required to be part of an Alva's house program. Even though he was on community control for a drug possession charge, he had this history apparently of assaulting juveniles. So knowing that, why would his attempts at luring young girls online be something that would be more than a mere technical violation?
well, I'm not disputing that they would not be if they were charged, if he were charged for that or had admitted to those types of things. That was all discussion by the lawyers at the hearing. He admitted he was alleged to have committed 2 violations, maybe 3, failure to complete the VOA program in the first violation hearing, then failure to complete Alva's house, the program at the Alva's house, and then failure to complete the reentry court, from which he was terminated as a consequence of failing to complete Alva's house. And the argument, or the point is, those are not criminal in nature. If the state had wanted to, they suggested in their brief something like attempted importuning. They could have indicted him for that, or they could have listed that as a violation. But that
Counsel, will our decision in Nelson take care of your case here?
I believe so. My only hang up is, I believe the appellant's position there said something like, if the court sends a guy to prison gives a guy a prison penalty for a violation, he can send him for the 90 or 180 days, depending on whether it's a 5 or 4, and then he's done, if I recall correctly. But I don't read that. I don't see that in statute. I think he can be on probation, do a 90-day stint, come back, still be under the court's supervision. That's one. And 2, he said something about leaving the state being a non-technical violation. I don't see that in the statute. It says C1 says if it's technical or a violation of crime, it's not a felony.
But that's not relevant to your case here.
Leaving the state, you mean, or his additional content? Correct, right.
Yeah, whether after he does, if it's technical and you're then put into incarcerated for 80 or 100 or 90 or 180 days, and then you have the rest of your community control to finish after that, provided you have a tail on that, I would say. That's not part of your argument here either. That's not relevant.
No, I'm just pointing out a difference in our positions.
Okay, thank you.
Okay, a couple other minor points. I think the other argument points to another one, and that is, when is a cap going to have any effect? And that's, well, when a judge really wants to stick a guy, and why would he want to? Well, he screwed up let's call it a substantive rehabilitative requirement. He screwed up something that was a big deal in his case. that's when the judge is really going to want to punish him. At least I would think so. And that's precisely when a cap has meaning, is when the judge would otherwise exceed the cap. To the extent that's accurate, then the MANA position is exactly wrong, because it's saying that's when the caps don't apply. Another minor point, Revised Code 147C says when construing a statute, it's assumed or presumed that a result feasible of execution is intended. And we've already got, I believe that the list of authorities in Nelson points to a whole mess of cases dealing with this already, and it's only been in effect for something like 3 years. So you're seeing that it's not feasible right now because nobody knows what technical means. And the definition they gave using this court's precedent to determine the meaning of technical violation is crystal clear, easy, easy to execute, and there's no question of the outcome in any given case. Kind of related to that. I may have said this already. In MANA, the 5th District said the General Assembly could have said non-criminal, well, by using technical, and this goes to Justice Fisher's point or question, by using the word technical violation, they did. It had the same meaning according to this court's precedent. I think that's kind of the brunt or the basics. I would reserve the rest of my time.
Thank you.
Thank you.
Mr. Bishop.
Thank you, Chief Justice O'Connor. May it please the court. I would like to start with the proposition that I hope we can all agree to, that trial courts need discretion. When we consider the myriad of criminal defendants each with their particular character, their particular history, their particular proclivities, and we combine that with the myriad of situations that can give rise to a community control violation, it's pretty clear that one size doesn't fit all. So that there is a need, and I think even with the paying due respect to the General Assembly's intention of reducing prison overcrowding, saving taxpayer money, and providing treatment alternatives for those that are addicted to drugs, we can still say there is a need for discretion in the trial courts, and we recognize that they're in the best position to determine, because they know the offender, they know the facts, they're much more attuned to the situation than any of the rest of us. With that in mind, I would say then that timing is not always critical, but in this case, it may be important to recognize the timing of the situation. And by that, I mean, when Inmates Council-matic Voice and later Taylor were decided back in the early 90s, 1993, to be a little more exact, approximately 24 years before the enactment of 2929-15B1C, they had a different focus. At that time, as you know, they were required to determine what was a reasonable time under due process analysis for parole violators to be brought before a court for a final dispositional hearing. And in ferreting that out, they did in fact recognize there generally is no 60-day rule, but in cases of technical violations, in some instances, there is a 60-day requirement. And so, of course, they did set forth what was then a working definition of what a technical violation was. And they did, in fact, say those violations of the terms and conditions of the parole agreement, which are not criminal in nature. That was fine. That was good, a good working definition back then. Now, 24 years later, the legislature, again, for reasons that are laudable, has enacted and implemented 2929-15B1C. And again, I won't belabor the purposes of that. But in doing so, the legislature had clear choices to make. They could have said, as was pointed out by the Manna Court, that all violations that are non-criminal have a 90-day cap if it's an underlying felony of the 5th degree. They chose not to. They could have said, we will distinguish between technical violations and non-technical violations. They didn't do that either. This, I submit to the court, was almost an engraved invitation for the court to decide. I think the legislature clearly here, especially given the fact that they're charged with the knowledge of prior case law and prior rulings of the court, clearly said, we're going to let the courts decide this. The state of Ohio, in this case with Mr. Katzner, is not asking this court to overrule Taylor. We're simply asking for clarification. There is a need here. I think we can all recognize that there's a need. And I would submit to the court, and please feel free to correct me if I'm being oversimplistic, but in my mind, there are 4 types of community control violations. Number 1, technical. Those that violate a general administrative requirement enacted merely to facilitate supervision. Technical. Non-technical. Those community control violations that constitute conduct that violates a specifically tailored requirement designed to facilitate the rehabilitation of that particular offender under those particular fact circumstances. Third, a violation that constitutes criminal conduct that is not a felony. Fourth, a violation that constitutes criminal conduct that is a felony or could constitute a felony. There's the need.
Counsel, what are you basing on those 4 classifications? What authority do we look to reveal that that's the definition of technical? Or is that, I mean, it sounds reasonable to me, but it seems to me if the legislature was, as you say, inviting us to do their job and provide a definition to technical, I mean, there should be some authority for that. I mean, you already cited some authority where that the parole board used that said technical meant non-criminal. I mean, why wouldn't we use that?
Again, in 1993, the Federal District Court for federal parolees did say we need a working definition of what constitutes a technical violation versus not, so that we can determine whether 60 days is sufficient under due process to bring them before the court for a final dispositional hearing, or whether, if it's not a simple technical violation, whether we can bring them before the court in a reasonable time that may be longer than 60 days. That was their focus. Now the focus, it would seem to be, is what kind of violation is this and what should we do about it? What's the appropriate sanction? And again, one size cannot fit all. I think we all recognize that. So in answer to the justice's question, what authority am I citing? I'm literally citing the language chosen by the legislature in 292915B1C, when they clearly chose, instead of non-criminal or criminal or substantive or non-substantive, they chose the word technical. And of course, we recognize that nowhere in the revised code is the word technical defined. That, I'm simply saying, as a common sense matter, is an invitation to this court, maybe not to define it, but to clarify it.
Counsel, would you agree with your with Mr. Avery that the Nelson case will pretty much decide this case?
I would, for the most part, yes, I would.
Okay.
I think it's important here that the trial courts need the tools. We want to uphold the law. We want to rehabilitate these offenders. We want to accomplish all of the things that the revised code is designed for. Trial courts need the tools to do it. And while we can't do a bright line test, I would argue, because again, if we do a bright line test, we've simply said, yes, one size does fit all. And we know that that's not the case. So,
okay, Counsel, you would agree this enactment was was done to reduce the time for some certain kinds of violations for some offenders. That was the major intent of it. We could at least discern that, right?
Yes,
We just don't know which ones they meant because we can't decide on what technical means, right?
yes.
Okay.
I think they left that to us, to the court.
To legislate.
And when we look at the term technical violation, why can't we split that down further and refine that to say there are two types of, if you will, two types of violations, technical and non-technical. Never mind for now, criminal or felony or misdemeanor. Technical means this, and by implication, non-technical means this. I don't understand why we can't define that to say there are times when a particular offender and the particular facts of a case require substantive rehabilitative requirements designed to assist and to help rehabilitate that offender.
Counsel, do you think that there's any times that a criminal violation could fall under the definition of technical?
The one that comes to mind, Your Honor, and I'm not saying I support it, but the one that comes to mind is a curfew violation. You know, it's certainly not against the law for adults.
Your status type of offenses, you'd say could be regarded by a court technical, or would you say that if we're clarifying things, those type of violations should be or could be included?
Could be, but perhaps the legislature has already made room for us there in the statute when we talk about any violation of law committed while under a community control sanction for such a felony, i.e. felony 5, that consists of a new criminal offense and it's not a felony. So I think they may have left room for those kinds of.
Okay, so that answers the question then as to the role that a low-level criminal activity would have in this realm. But even a felony, a new felony, which obviously is not technical, that still doesn't dictate that a judge has to send someone to the institution, violate them and reinstate the incarceration.
If I understand the Chief Justice's question, yes, I would agree. There again, there is discretion in the trial court. The trial court can say, look, you were on supervision, you committed a new felony, I could send you to prison for a long time. In my discretion, I'm not going to do that. I don't think the statute prevents that. The state's argument, and we do, of course, rely heavily on the Manna decision. The legislative intent was left open. That's probably the best we can say. They chose their language carefully. They adopted the word technical as opposed to criminal or non-criminal. And they purposely then, well, maybe I shouldn't say purposely, but glaringly did not define that term when they certainly had an opportunity to do so. I submit again to the court that until this court takes up that invitation and refines, I don't want to say overrule, I don't want to say define, I want to say refine the term technical violation, the courts have to rely on the Manna decision, I think, and it's sound reasoning that there's certainly a big difference between contacting young female girls when you're supposed to be in sex offender treatment at Alva's house. There's a huge difference between that and failing to report or leaving your employment.
But was that a violation that he was found guilty of?
If I understand.
In this case?
He was found guilty of contacting young girls while at the Alva's house. He was terminated from Alva's house for that, where he was supposed to be, among other things, getting treatment for his proclivity toward young girls.
But the basis of the violation was that he was, so that would be criminal, that would be felony conduct, and then that wouldn't be subject to the caps if that's indeed what he was found in violation of,
I'm saying,
regardless of whether he finished treatment or not.
I'm saying it could be. And I would concede this as well. At the violation hearing itself, upon consultation with counsel, he elected to enter admissions to the petition for revocation. That, I guess, in a sense, is a little unfortunate. Had the case proceeded to a full hearing, more facts could have been developed about his actual conduct at Elvis House. What we're left with, from the record at least, is we know that he was obviously on community control and sent to Elvis House to complete their programming. And within 3 weeks of being there, he had used the facility's computer equipment to set up a Hello Kitty email account, which is specifically geared toward young children, and had in fact contacted a variety of underage girls. And there was some discrepancy in the age of the girl. There were references, I think, by the court and probation, as well as the state, to whether the child was 13, or at one point there was a reference to 12. The petition originally set forth 13. It was finally adduced that the child was 10. Either way, the importuning statute addresses that because it breaks it down into less than 13 or less than or greater than 13, but less than 16. So either way, it would have been a felony. But again, it's unfortunate that the hearing didn't go forward in that sense, but I'm hoping that I'm answering the court's question that yes, that was the basis of the violation, that he engaged in those activities with young girls. And in fact, it was developed that through the computer, he did manage to contact a girl, exchange phone numbers, and had actually spoken to her a couple of times.
So that would make this case significantly different from the Nelson case, because we have a fact that would, if true, would be a felony.
I'm a little hesitant, Your Honor, because it wasn't developed more. I would say this, as we argued in our brief, it certainly could constitute attempted importuning. What I would have liked to have seen, again, had the case gone to hearing or had more investigation been completed, was literally how far down this path of attracting young females and targeting them or trying to offend against them, how far did he get? Well, we know he got as far as setting up an account, getting them contacted, having communication with them, and that he certainly had a proclivity and prior record of sexually assaulting young girls. So yes, it could constitute alleged importuning.
Thank you, Mr. Bishop. Mr. Avery?
Thank you, Your Honor. I want to address that last point briefly. The September 19th, 2018 notice of hearing on a probation violation alleges 2 counts. One is on or about September 2nd of 2018, you were unsuccessfully terminated from the Elvis House in Chillicothe. On or about, and violation 2, on or about September 18th, you were unsuccessfully terminated from Richland County Reentry Court. Those are what he admitted to doing. There was no hearing on the other matters, so there's no felony in question. The question is whether these violations, termination from these Reentry Court and Elvis House, are subject to the caps. The argument is they are, because they're not criminal, so they're therefore technical. And the sentencing entry dated November 5th, 2018 says specifically, accepts the defendant's admission to community control violation, count 1 and 2. Those are the same ones I just read off to you. So there's no question of a felony here, at least as a matter of the record. If the state wants to investigate that and indict it, they're obviously free to. And that's going to be subject to its own set of, retribution, punishment. Mr. Bishop's argument seems to be primarily that the legislature intentionally left the door open, and he called that an invitation for the courts to have discretion in this. And if they had chosen some term other than technical violation, and again, I would I'll just read the quote. I put this in the brief. It's from Chesapeake Exploration v. Buell. In enacting our laws, the legislature is presumed to know the meaning of words and to have used the words of the statute advisedly and to have expressed legislative intent by the use of words found in the statute. They used technical violation for a reason that was already defined by this court in 1993. As far as I can tell, that is the rule until they change it. As I argued in the my memorandum, there's no basis under Westfield Insurance v. Galatas to overrule that definition, or there's none of those reasons are satisfied for overruling that or changing that definition. In other words, it is what are they? It's feasible of execution. It was not wrongly decided at the time, and there's no undue hardship. None of those are in play. In fact, it's the opposite. There's hardship from litigating this issue, the meaning of this word that's already defined. It's quite easy to use a bright line rule that we already have, and there's no reason to think that that rule was wrongly determined. As far as considerations about overcrowding, I think those are irrelevant because the Revised Code 149 says you consider the intent when a statute's ambiguous, and this isn't ambiguous. Technical violation already had a meaning. Doesn't have one in the Revised Code, but it has one in the case law. I think this is a major point too. This statute doesn't, or this amendment doesn't have any meaning where the meaning is ambiguous, because a court can always determine, hey, this matters to this guy, this matters to this guy, this matters to. When would a judge that wants to send a person to prison for longer than the caps or than the limits not find that it is non-technical? In other words, when does this have meaning? Well, it has meaning when a judge is forbidden from sending a guy or probationer to prison as long as he wants to. And that is not going to be when a judge determines that a violation is not technical. So, yeah, not technical. If he's got the discretion to determine the meaning of that word. I kind of got it. All right, thank you.
Thank you. Thank you, gentlemen. We'll take the matter under advisement and you'll be notified of our decision. Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.